If you go to the online site attached to this class, you will find some links about the complaint that you're going to do on Thursday. I've also printed you off a complaint to just take a look at. I don't really think you should just simply cut and paste and think about it like that, but I thought it was a good complaint because it's one of the Walmart complaints, and it's interesting. But the fact pattern of the complaint that you need to do on Thursday is also posted online as well, with some other links of information from both the federal court and our state courts as to things you should consider when you're filing the complaint. So I hope you look at that. I mean, the idea is that you shouldn't, most of you have already done this in one form or another, but you shouldn't be able to get to law school without knowing how to file a complaint, since if you're going to be practicing civil litigation, sooner or later, you have to file a complaint. So the fact pattern is pretty straightforward, and I think when you look at it, you shouldn't have an issue with it. I'd like you to file it by next Tuesday when we meet again. Okay? Questions on that?
Online.
What?
File it to your email.
No, file, I think well, I didn't say explicitly that it should be in the state court. I think it probably should once you look at it. I think that's probably the likelihood is. And in state court, you'd be filing it in hand anyway. So I would recommend that. You might be able to figure out a basis to file it in federal court. I'm not sure I haven't given that much thought. But I think it's probably best to put in Superior Court anyway. So you should plan to do that and file it physically in hand when we meet again. And even those that are taking the class online should submit it, a hard copy, or at least at the minimum, if you want to submit it by email, a hard copy, I would probably accept that from both your groups. Okay?
Excuse me?
Yeah.
Are we not meeting on March 3rd?
You are not meeting on March 3rd. I have to go to Boston on the 3rd for the American Association for Justice trial competition.
So the assignment is...
And we are not meeting the following Thursday either, unless those are, actually that's the date that's now scheduled for our exam. So I don't know how many of you have looked at the questions and decided you're going to take the exam as opposed to submit those online questions. Do you have any indication yet? Yeah. Yeah, what? You're going to take the exam, or you're going to submit the question? How many are you going to take how many are taking the exam? Okay. It's fine, there'll be an exam here, there'll be someone here. Okay?
So the questions are due after the break?
Questions are due the Monday when we return at midnight. So that would be, anyone know what that date that is? 15th, 22nd? Does that sound right? Or 22nd or 21st? 21st? Amy says it's the 21st at midnight. Midnight at the conclusion of the month. What?
And one other question, the complaint, we're supposed to email that to you for?
I will accept a attachment by email or a physical copy handed in on Tuesday.
Okay, so by Tuesday
okay.
It's due, not...
So, well, that's due by the next Tuesday we meet.
So it's due next Tuesday?
Yes, because the assignment's really for you Thursday.
Okay, but we're not here Thursday.
You could be.
I mean...
I won't be here.
Okay. So...
In other years, it's been designed that you sit here and write the complaint in an hour and 15 minutes. It's not designed for you to do 10 hours worth of research and legal work on. It's a pretty straightforward problem.
So it's due to you next Tuesday then?
Correct.
Got it.
Okay. It's still due Tuesday. Okay, we all good? It's pretty straightforward. Don't obsess about it, but you should know how to file a complaint. It's I think it's a pretty straightforward fact pattern, and especially when we talk about remedies, you know, all the time. I can't tell you how many times when I had a much higher caseload that we were filing complaints for injunctive relief or specific performance or things along those lines. It's a pretty regular occurrence that you invoke some type of equitable remedy in a variety of cases. That's just a sample. Okay? I just want to touch on Rule 23 quickly because it's in our schedule for tonight as well. Rule 23 is class actions, and you know, I think law school, as law schools, we spend a fair amount of time on it. It's rare that you really get exposed to it because it's pretty much a specialized practice. From time to time, I've been consulted about a few, and you look at them and you think about getting involved with them, but the likelihood is it's going to be that and maybe nothing else at the time, because if it really is a class action of some size, the problem is that it'll consume much of your weekly, monthly workload. And so people might call with problems, and they may ask you what you should do. And while we tend to think of them as relatively small dollar claims, they are not all small claims. So sometimes class actions, I think the example we gave you, I thought if this is not the class action one they're asking, there is another class action count for Walmart, class action complaint for Walmart that is, no, I think it's just a straight complaint, that has somewhere virtually every female employee of Walmart is potentially a member of that class, so it is a huge, huge class action. But a class action, what we do when we shorthand the explanation is there are really 5 whys that the court looks at if you want to add in manageability, which is the 5th factor that some courts now look at as to whether the class is manageable, because sometimes it gets so large and so unwieldy that it can't be managed effectively. So manageability sometimes is referred to as the 5th why they look at. But the other whys are commonality, typicality, numerosity, and adequacy. And really what you're trying to show when you bring a class action is that there's been a group too numerous for joinder who have been injured as a result of common questions of law or fact. And then what you have to do when you bring that case is show that the named representatives, fairly and typically, their injury represents the injury that the class members have suffered, and that this class representative can adequately represent the interests of the class. And part of that analysis actually then it will entail your ability to represent the class member. And so from a standpoint of being a new lawyer, it's oftentimes difficult to get approval to file that class and represent the class without more experienced representation with you. And so that's why it almost oftentimes becomes a fairly specialized approach to practice, because you'll likely never be appointed as main class counsel until you've done a class action, which is sort of the chicken and the egg if you work that logic through. So a lot of times what happens is people will come across a situation and they will call a more experienced counsel to ask for assistance with it and evaluating it, who may be able to be the class representative. And you know, the fact is it oftentimes doesn't benefit the individual plaintiff, but there may be cases where you won't take them unless that there's sufficient numbers that make sense from you financially for you to be able to do it. Someone talked to me about a wage and salary violation case, and it was pretty clear that there was a violation, statutory violation that was meaningful, but at the end of the day, when you did the damage study, it probably didn't appear to amount to much more than $1,000 a year for the injured person. Frankly, to put all that time into that case for a few $1,000s within your damage limitation period, it doesn't make economic sense to do it. You bring 50 or 100, or if you're really telling me there are 500 employees similarly situated, well, that's a lot of money. And then that might make sense for both you to be involved with the case and to bring it through by way of a class action. And so the plaintiff could go to small claims and try as best they could, or that might be the type of case where it's not $5 or $100, but there's a few $1,000 that still, frankly, isn't necessarily worth pursuing for just that plaintiff. But if you have enough people similarly situated who have been injured like that, then it makes sense. I think you see a lot of the wage and salary cases, the tip cases, and those type, the failure to pay overtime when due. Oftentimes now, that's where the people start to look and see, well, is there a class that we can put together that make more sense to pursue the claim that way? And it's not a bad way to look at it, because you're not going to pursue a claim for $500 in overtime wages in all likelihood, because there's no money in it for you. But the fact is, if you can get enough people, then that claim may well make sense. One woman, forget her first name, it's Liz Reardon. At this point, her practice is almost, well, principally is the tipping cases, the way in which they share the tips and who gets to benefit from it. And she's brought numerous cases on behalf of the employees at the various establishments who feel that their tips haven't been properly attributed to them. And so you might have a few people come in to see you, but again, that's a tough claim to bring on its own. As a class, you've got some significant potential damages that make it make sense. So we also have, though, under Rule 23, a class action, what they call Class Action Fairness Act, that makes it much easier to remove a case from state court to federal court in the event that the damages are at least $5 million or more. If there are claimants throughout the United States involved in that class, then all that's required in order to remove that case is what we would call minimal diversity, meaning any plaintiff and any defendant from different states. And so it makes it much easier to remove that case from state court to federal court if brought as a class action as well. So it's another consideration for you in the event you don't particularly want to go to federal court. Questions on class actions? Let's talk a little bit about contracts to arbitrate, mediate, and forum selection issues. And we've got Carnival Cruise Lines versus Shoot, which you should have read. And then we also have a bunch of other more recent cases as well. And actually, some of them are more recent, some of them are older. All dealing with forum selection clauses. And I think that this is something that you need to be cognizant of. And actually, if you looked at the contracts to mediate in the language that's within some of the cases in the statutes, federal courts favor your obligation to meet to arbitrate because it keeps you out of court and gives us a fixed solution for how that can proceed. And I gave you the article, Federal Judge with a Radical Past Goes Mainstream, because I want you to start to think about how the judge's background influences the case. And as it turns out, this judge has agreed to be the law day speaker as well, which I think Professor Sullivan just told me last week, and I think you'd enjoy meeting Judge Gertner, but she is, her background is very atypical of federal judges. One big distinction is that she's a woman, and even still today, there aren't as many women on the federal bench as many of you would probably think would be appropriate. Maybe too many for some. Let's talk a little bit about Carnival Cruise Lines first. The Chutes are injured. I think you've all probably read this at one point or other, but the Chutes are injured when they're on a ship that leaves from Southern California, and the injury appears to be somewhere off the coast of Mexico. They left from Seattle. They purchased their tickets in Seattle. There's a forum selection clause within their tickets, the non-refundable tickets, that says that if there's any injuries that arise howsoever, that they have an obligation to go to Miami to file that suit. Despite that provision, they file suit in Washington State. And let's get the law down first, and then we can work out the issues of fairness, arbitrariness, or whatever else you'd like to discuss. Supreme Court of the United States, is the forum selection clause that the Chutes, that was placed on the Chutes tickets, is that an enforceable provision? Yes. Yes, it is. Why is it? an enforceable provision.
Based it off the agreement case, what they did, even though it's vastly different facts, they based it off that case, and they said that it's basically a contract, even though there's not bargained for, there's a contract about forum selection clause placed in the contract.
And they had knowledge of the clause, and despite their knowledge of the clause, they went on a cruise. Now they're bound by the provision tucked in that tiny language on the back of the ticket, because it's a contract. What are you looking at me askance like that for?
Plaintiff's counsel blew it.
Why do you say that?
First of all, no one reads the backs of those tickets, all right? And they certainly didn't read it before they purchased the ticket. You have to purchase the ticket in order to get it.
Correct.
All right, and that, I think that the court based its decision on plaintiff's counsel admission that their client acknowledged, read it, and understood it, although, albeit, what was the exact language in the brief of the complaint or the memo, whatever they filed that the court quoted?
I don't know, but what if it's
What fine print? You know, if you can place any credence on the fine print, the 5 paragraphs of fine print they read on the back of the disclosure. That's, I think the court based it on that. If the plaintiffs had alleged that they didn't read it, they didn't understand it, I think the decision could have been different.
Well, when you say they didn't, because I've got 2 questions in that regard. The plaintiffs didn't read it and didn't understand it. What's not understandable about it? Because then we'll come back to your first part. You guys all read the clause. If you've got any problem, you've got to file in Miami. I mean, we've all been in law school too long that it's very clear to us what it is, or you know what that says, don't you?
I looked at it like a contract of adhesion. You had no opportunity to negotiate that.
Well, I'm not sure it isn't a contract of adhesion.
Yeah, and look at what they do with contract of adhesion.
So what? You knew about it, and you nonetheless set foot on the boat. Because Francis says, well, they shouldn't have understood what it says.
You don't have any ability to negotiate that.
So what?
You cannot go to a...
No, I'm serious. So what?
Well, I don't think it's fair.
Oh, it's not fair. Does fair matter? No. I don't think it's fair either.
Well, look, from all of the cases we've studied, these contracts of adhesion are given short shrift by the courts.
But you read this case.
And it's not given short shrift by the courts.
No, it's not. Go ahead, Ted.
But it's not too far different from the lift tickets on a ski mountain. Nobody reads the backs of those. They're just like, okay, well, here's my ticket to ride. But you read it, you know, you trip and fall and break a leg, you got nothing on the mountain.
They're treating the way down.
And you can't negotiate that either. You go to the office or customer service and say, I don't agree with this. I want to have my rights to, you know, protect myself. They're going to go, well, you can't ride that.
Yeah, get your money back.
So here's your money back and go ski somewhere else. Nobody reads those, and the only reason I really paid any attention to them is because of Martin. And when he made us bring him in, because you know, if you want to go on the cruise, there's certain things that you have to concede to.
Don't you? Don't I, as Carnival Cruise Lines, have a right to say, listen, these are the conditions of your travel on my ship, and if you want to come on, here's the deal. This is it. That's what I can do.
Absolutely, I agree. I mean, I think that I agree. Customarily, people don't read these contracts of adhesion, if you want to call them that. But I think the greater issue is, did they have an opportunity to? Could they have read it and then agreed to the terms? And if they could, then they have to abide by the contract.
Well, because you guys are agreeing to these all the time, aren't you? When you go, I accept.
Every time iTunes updates.
That's what it's like.
Right.
Because before, you agreed as soon as you clicked accept, even though you didn't know what you would agree to.
Right.
And this is exactly the same thing.
Well,
you're agreeing to it, but you can only agree to it by buying it, so you don't know what you're agreeing to. That's the problem. The court seems to completely ignore all that. They just go on the inconvenience. They say the shoots have their heavy burden of proof that it's inconvenient for them. Forget that they didn't negotiate it for it.
Think about how many people go on a cruise every single year with Carnival. They're out of the millions of customers that they have, a few instances come up, and it makes more sense from a business standpoint for Carnival to put the arbitration clause in there, because they don't want to have to go traveling all over Halifax just to satisfy a few upset customers.
Well,
Well,
it
you know what,
would
that's
tend
the
to
arg-
discourage claim, despite what the court
But
said.
that's the argument that they put forth, but if what you're saying is true, that there's only a few, then that gets rid of that argument, because they have such resources that if they only have to contest a few, then it's easier for them to go than to make people with minimal resources come to them. But I don't, just if there was a large volume, then.
I mean, yeah, there's the strategy advantage to the forum shopping. If I can put an arbitration clause and keep it in my home court every single time,
Oh, yeah.
then I'm going to. And so if you were in their position, wouldn't you?
Bottom line
try.
here, there's no mutual assent, all right?
Yeah.
And that fine print.
Is that really true?
That
You
fine
assent
print on the
by
back of that,
agreeing
yeah,
to
the
it.
fine print on the back of that ticket basically incapacitates the plaintiff.
Wait a minute though, when you step on the ship, knowing that provision exists, how is that not mutual assent?
Yeah.
But
Yeah,
then
you
you
have- you
gotta
have-
back up though, if they don't know it exists until they buy the ticket, and the ticket is non-refundable, that's
If-
my problem.
If this were a suit for refund of the money because they read the clause and they decided they didn't want to comply and they wanted their money back, then I'd say
You could be in Washington
Carnival's
State.
got a problem. But this isn't. I mean, they had ample opportunity after they purchased the ticket to object to the clause.
Take it to their attorney and have them examine it and then file suit.
Just to simply ask for their money back. They never asked for their money back.
Yeah, but didn't the ticket say you
Ticket
couldn't
says
get
it's
the
not
money back?
refundable.
Ticket
The
said
ticket says it's not refundable, and the court's saying that if the
Well, but-
court's
but-
saying
but-
that you gotta go
but
to
that's-
court in Florida,
But that's the
court's not
point
gonna
where this
just give you
issue
the
should
money
be
back.
explored then, doesn't it? Yes, the ticket says non-refundable. However, I've now got it, as John points out, well, I'm not agreeing to that term. I think, and I do agree, I think legitimately they could file suit in Washington State and shouldn't be bound by the provision of a clause they didn't agree with.
All right, how-
But once, I need to know from you, once with knowledge, they step on that ship, how is that not mutual assent to the provision?
Okay, I have an analogy, okay, how about this? You buy an automobile, $50,000 automobile, you drive it home, you get into the driveway, you open up the glove compartment, you look in the owner's manual, and in the owner's manual, on the back page of the owner's manual, it tells you that you cannot file suit if you have any problems with this car, you have to submit to arbitration.
Okay?
You bought the car, you had an ample opportunity to examine the owner's manual before you bought it.
Oh, you did?
Well, just like the ticket, why
No,
not?
you said the manual was in the glove compartment.
Hidden
Well,
away.
well, they hand you the manuals when you pick it. They hand you a stack of books and manuals and papers, and here, sign this, and off you go, and you're happy, and you got your car, and you jump in it. You drive home, and you find out on the back of, what it was, say it was the contract.
Okay.
Or the purchase and sales agreement.
You
or-
now see it
or
for the
bill
first
of
time.
sale. No, okay, how about the bill of sale? The bill of sale, on the back of the bill of sale, there's a disclosure that says you have to arbitrate.
And did you sign the bill of sale? You must, no?
Maybe not. No, bills of sale, you don't sign bills of sale, you just get a bill of sale.
So at what point did you acquire the knowledge that that provision was there?
After you made the purchase.
Okay, but before you drive the car or after you drive the car? Actually, I don't care what point it is. When you first have the opportunity to be aware of that provision, at that point, if you don't take action to void the contract, you're in. You're confirming your assent to that contract, is what I think. And I don't like the provision here, and I don't like the way it works, and I don't agree with the court. I think it's absolutely designed to discourage some people from filing claims. Because no one's going to be running down to small claims down the street now where it's nice and easy. And Carnival's not going to have to come in to podunk small claims court, so it's good for them.
And you know what? Nobody's buying that idea that there's economies of scale in Florida courts, all right?
I don't buy that either.
You
I
know-
think it's all unfair. Tough luck though, it's the law, isn't it?
Well, let me ask you one question though, because you brought up a good point. Would they file in state court, or would Carnival in this case, even if it was filed in Washington, look to remove to federal court?
No, I thought the provision only is choice, I thought it says any court in Florida, isn't it? Don't worry about that. In the state of Florida, doesn't say state or federal court, so any, before a court located in the state of Florida. So it's only gonna go in Florida. You have your choice once you get there. See, I don't care for it either. You don't even think it's unfair, right? I can see you shaking your head when I said. why don't you think it's unfair that they have to go, what, 3,000 miles in order to file suit? I mean, well, it's on a controversy having virtually zero connection with Miami or with Florida.
I think that the companies that sell a service have the right to provide the terms of that sale adhered to. If you don't agree with the terms of service, then don't buy the service. If you make the argument that the terms of service were not clear prior to the point of purchase, they certainly had ample opportunity between the point of purchase and the point of delivery of the service to object. Failure to read it, I put this strictly in the category, the stupid shall be punished.
But isn't that unconscionable though, to slip it
I
in
find
into the
nothing
fine print?
unconscionable
of-
about a
of-
contract that people are too lazy to read.
Well, what about the lift ticket?
You can't
You know what I
change the
mean?
contract.
You've got ample opportunity there too. Read the lift ticket.
Well, you know there's lots of language. Did you ever read your baseball tickets?
Yeah.
They all have,
Parking tickets.
Pretty much, if they don't like you, they can throw you out, you don't get a refund, you don't get another voucher for another day. The only like concession that Fenway makes is if there's a rain cancellation, they'll give you a voucher for that. But other than that, like they set out all the rules and they say at any time, park officials can remove you.
well, let me ask you about the onerousness of the online transaction, right? You're all clicking through all of that these days, right? Do you want to see the entire agreement, or you just want to say accept? And how many of you, no, none of you are really looking at it, are you? Right?
We're just saying iTunes. iTunes updates like every 3 weeks.
Yeah,
It's
they change it
ridiculous.
every day
And I'm not
too.
gonna
God
read-
knows what would
I'm
agree
not
to
gonna
that.
read
We
you
got
the
to
35 pages of the legalese every 3 weeks.
Well,
So,
what
yeah.
about that? Because that to me, at least there, they've got a piece of paper they can look at. We don't even want to be bothered. But if you bought something on eBay or through PayPal or Craigslist, you've agreed to various provisions there when you put your listing up or whatever. Do you know what? You don't know what they are, do you? I printed off eBays and PayPals one time just for the purposes of this exercise. They're like this. They're like this. This couldn't possibly. And that gets us into this question, because I think it says contracts to arbitrate, mediate. I mean, because that is what we're doing here, right? You're waiving your right. Here, at least, they get to go to court. You could waive your rights to go to a court at all. So therefore, waive your rights to a jury trial, which companies like that, because it helps make things even more clearer for them. The businesses oftentimes worry about juries. You could go halfway across the country, and it could be just some type of compelled arbitration that'll be over toot sweet. Everyone, good for everyone, but not necessarily you. And this was 91. I don't think in the last 20 years things have gotten better in this regard for those agreements, because you're entering, you all probably entering into 5 of those agreements a day these days.
I found a case on point, kind of goes about this a little differently.
Okay.
So basically, it was a case in Worcester, and this couple wanted to go on vacation. So they freaked out because the vacation was right after September 11th, and it was a non-refundable ticket. So that's it, they're out, right? And they got the tickets with the back of this forum selection clause. So in that case, actually, it was kind of interesting, because they cited this case and they cited another case, and they actually won. And the way they went about it is they used the Mass General Law Chapter 93A statute and filed like a notice for unfair and deceptive acts against that company that wouldn't give them the refund. And then through that, they circumvented this ruling and got under the Chapter 93A to get their refund. And that's how they won. So that's kind of a little trick.
Saying the provision itself is a fraudulent and deceptive trade practice of some sort.
Exactly.
Yeah.
So that was, I forget the name of the case, but it was kind of interesting, because it was a different way to get your money back, even though you agreed to all these terms right in the back of the thing.
Didn't go on the trip, did it?
They didn't have to go on the trip, no.
But they got their money back.
But they had their money.
But, well, then that's right too. They didn't go engage them. They didn't show us that.
I was gonna say, all of those contracts that you see online before you click, they're intentionally so long that you don't want to read them, so you just scan through them if you do anything. You certainly have the option to read them and object to them, but most people don't. And they're so lengthy and convoluted that people just don't. It is just a tactic to discourage people from doing it.
Well, on the other hand, you know, this is
But they have the
the
opportunity
corporate
to.
lawyer's revenge against tort lawyers. Because the reason that those things are about a mile long is because the tort lawyers have gotten so adept at weasel wording lawsuits that hold them liable. So you know, I find zero sympathy for the argument that, oh, it's too complicated. It's too complicated because the tort lawyers have done it to
Chose
them.
not to.
It's the tort lawyers, not the greedy business lawyers who are
That's
responsible
absolutely-
for all of this.
Well, they're all a scourge upon the earth.
That's right, I forgot. So let them eat their young.
Plague on both their houses.
I just want to make one point since we're on the topic of lawyers. I agree with John, but for a different reason. I think that
What? All lawyers have horns in a red cape?
well, yeah, I agree with that too. But
Oh, you just agreed today, no, but it's general philosophy.
right, just today.
Oh,
Yes,
okay,
yes.
okay.
Thank you. I don't think it's undue hardship because the couple here would have to hire counsel, and it really doesn't make a difference whether their counsel is in Washington State or in Florida. They have to hire representation, and really, who cares?
Except everything becomes more expensive. If there's gonna be discovery, it's likely gonna be in Florida. If there's gonna be motion hearing that they have to attend, they're now moving to Florida. It's gonna be.
So they're going to bear those costs.
Yes, so there is an additional expense here, and so that's, see, I disagree with the court's note, I don't disagree with the result, but I disagree with the court's notion that, well, this is not designed to discourage anything, it's no suggestion that it's a less fair forum. Oh, there's definitely an incentive by the company's lawyers to make sure those greedy tort lawyers don't get their piece of this pie and to make it more difficult for people. Someone comes to you with this ticket that you're a lawyer in Washington State, you're going to say, well, listen, your claim's worth $3 grand. It's going to cost us $5 grand to hire a lawyer in Florida. We still want to do it? What's the likelihood that that claim is going forward? And the answer is virtually none. And even the notion of having to engage counsel and to then have to participate in this you know, cross-country piece of litigation, it's infinitely harder. And so I don't think that whole cost savings goes to the consumer. I think it's a business practice. But I do agree with John that I'm not so sure that, I'm not so sure. Why can't the business set its standards? And the problem here is they say, well, we knew. And with that knowledge, they set foot on the boat. I think they've assented to it. I think it's worse. I think the decision would be the same if they said, no, we didn't bother to read the ticket. But you could have, right? I mean, so when you tell me you didn't read the provision that eBay or Craigslist or whoever it was that gave you, you just said, I accept. So I didn't know what it said. Well, you could have read it.
Buyer beware.
Well, but it's not just buyer beware, is that the ignorant and the stupid get hurt, is John's point. And why shouldn't you? Right? And I'm not sure it's fair, but it's the law, remember? Go ahead.
Yeah, but I don't necessarily think it's that. I mean, everybody knows they're there, but they don't really care until something happens to them. So I don't think it's the ignorant, ignorant
Right.
people don't read it. I don't read those. I know it's there. I don't care. I want my stuff. Right?
Well, but you're being ignorant of your own rights at that point.
No, but
So
like
still-
if
it's
you
just-
consciously
if
waiting.
you're like consciously
Oh,
aware
yeah,
of
fair enough, and that's different than ignorance.
like if you consciously
Willful blindness.
Yeah.
you want to purchase stuff so you can only arbitrate in California, then to me that's stupid. Like to me, and I think to the average person that would be odd for me to be like, oh no, I only purchase stuff where I can arbitrate in my home state to be safe in case something happens. To me, that's illogical. It's like I want the stuff. The odds of something happening to me are slim, so I don't care. I agree. And I feel
But
like
you're
that's,
running the risk that we lawyers tend to be adverse about. That's the problem is.
But like,
you
what
know,
choice do you have now? If you want,
well, you could try and find someone different. I think you're right. At the end of the day,
You
it's
have
such a
to pick
widespread
one.
practice that, you want to rent a car? How many times you gotta initial the stupid boxes? I'm not gonna sit there and read all those boxes. And I know the fact is, if I can go to the next, I can go to budget, or Hertz, or go right down this aisle, they're all gonna make me initial the same damn thing. So I'm not gonna spend, what am I gonna spend time reading it to know if I get in an accident, I'm screwed, right? Give me the insurance, and I want your representation that if something happens, you're not coming to look for me, and we'll deal with it from there, because I'm initialing all over that stupid form, giving up God knows what rights, but I'm not gonna sit there and negotiate it with the 22-year-old kid behind the counter, because he's got no rights to do it anyway. Oh, listen, can we get rid of this clause? You know? What's the chance of that, right? And that's the problem, is that it's become so commonplace, as you may not, you don't have a choice, for all intents and purposes. Isn't that the ultimate contract of adhesion? No matter which rental car I go to, I'm waiving an incredible amount of rights.
But if you want to be covered, we can double your fee.
Yeah, exactly.
And then,
I hate that
then
too.
you're all set.
Right. I'm with you. So it's all designed to even make more money. Huh? I'm not sure it's collusion or antitrust, really. I think it's that it's a business practice that they all do. You know, I mean, that's the thing. Someone could make some good money renting cars if they said, you know, we're not going to make you sign all over the form, and we're not going to jack you up when you get into an accident. We're going to cover you, and we're going to give you a low price, period.
Be out of business in a week.
Well, that's what I'm sure the worry is that these cars come back, they get digged up. It's not my car, what do I care?
See, there you've always got the option. You can not take the insurance.
Yeah, agreed.
Right.
Agreed. And I don't always take the maximum, because, but I could get a little worried sometimes too.
They're not going to rent it to you. They're going to get paid one way or the other.
Yes, but
they don't say, okay, I can't rent it to you.
no, but I've had people come talk to me when they've been in that boat when something's happened, and you don't then get to pick and choose what auto body place takes care of that vehicle, and the numbers are huge potentially. If you waived your insurance and now your insurance says, well, we're not going to pick it up. Mr. Fisher isn't sympathetic to your plight at all.
I'm not I'm just saying, at least in that situation, you have a choice. You can say, I don't want it, or I do want it. You've thoroughly opened yourself up to, you've exposed yourself. But at least you willingly chose that. That's different than this. You bought the ticket. And I see your point of, once they read it, okay, I get that, but they didn't even get to read it until they bought it.
I'm going to make a Francis argument for a minute, though. Willingly, we, lawyers, and the law are supposed to be the advocates for stupid people, right? Stupid people make mistakes. That's what they do. And maybe this was a stupid decision for the Chutes to step foot on that boat, but they did it. That's it, though? So because they're that stupid, because you're that stupid not to take that insurance for $10 a day on your rental car, that you now owe them $7,500? That's, geez, I don't know. I thought the law is supposed to protect stupid people and
Yeah, but
fools.
who honestly reads those? You
No,
seriously?
I know. I'm not kidding.
That's why I don't understand why it's.
'Cause I don't think it
you
makes a
think it's
difference.
like so appalling that they didn't read the thing. I don't read the thing ever. I don't read it on my
Just
plane ticket. I don't read it on a family ticket. I don't read
Because
it on
somebody
iTunes, I don't read
willfully
it.
doesn't take the insurance, that doesn't make them stupid. That means they're willing to take a risk.
But with full knowledge of the risk, you really thought that someone's going to send you a bill at the end of this little 3-day weekend for renting that car for $10,000? Were you adequately? Did someone adequately explain that risk to you? Or you figure you would say, I'm saving $8 a day. Good deal. No. Because that's what I wonder. I mean, like,
No, but isn't that the median between?
because I'm not even
what-
sure the accident has to be your fault for you to then owe unless you have the appropriate insurances. Right? I think that's true. That's worrisome. I'm okay with the law, but I do think lawyers and the law are supposed to be advocates for those people who can't take care of themselves appropriately. I do believe that. I hope that's why many of you decided to come to law school, because there's a lot of people out there like that.
We that are strong should bear the infirmities of the weak rather than please ourselves.
Only to a certain extent.
Roman 15.
Profound.
Well, but is that what it is? This is just survival of the fittest? This
So
is
it's a
not
state of-
society, there's no.
It's living in a state of nature in business. You know, if we allow this to continue, if we allow businesses to disclaim their way out of liability, you'll paralyze commerce. People won't be able to step on foot a boat, won't be able to buy a computer, won't be able to buy a car, unless they bring their lawyer with them.
Well, go ahead, you wanna make your argument? I assume you would say it'd be better off without.
Is that what you want to do?
Business, everything would function more
You
smoothly.
want to paralyze commerce and so that people.
If you
are
want to
so
paralyze commerce, all you have to do is to start letting people off the hook for their dumb decisions. And you ask the question, who is the logical candidate to pay the consequences of an error? Is it the person who makes the error, or the person who foolishly rented them the car without the insurance? I mean, you could say, hey, you must have insurance in order to rent this car. It's an extra $10 a day. That's it. And people would scream bloody murder about adhesion. They're jacking the price up. Because 99% of the people who rent a car never get in an accident, but they're all paying an extra $10 for the guys that do get in an accident. So how unfair is that? All those poor folks who now can't afford to rent a car because they're paying insurance,
That they don't want to take.
mandatory insurance that they don't want to take. So the car insurance companies, or the rental companies, give the option. You can either pay the premium and get covered or not. Your choice. And
Yeah,
that's,
but the choice isn't hidden in some fine print at the back of the contract.
they'll tell you,
Sure, I understand.
you must specifically waive the insurance
Right,
premium.
right.
And they
Okay,
show the cover
so let's get off this
that's
car
acceptable.
insurance.
That's acceptable, but how about when these folks bought this ticket on Carnival Cruise Lines?
In this case, you're not looking at waiving insurance, you're looking at waiving a form, a very technical, legal.
Or waiving a right to sue, is that what you're saying?
No, you're not waiving a right to sue, you're waiving a right to sue in your hometown. And quite frankly, I don't see that the Chutes here trying to get their money back because they disagree with this term of adhesion. They had more than ample opportunity to object to it. They made no effort to either renegotiate the terms or to cancel the contract.
The terms on this contract, though, were even worse than what was in here, because you actually had given us
Yep,
the
you
back.
still have it in your pack, you guys still have it, because it's in my drawer, it's in the.
And I mean, it was like, they weren't covered by any negligence of any employee. I mean, they had total disclaimer across like everything.
Yeah.
It was insane.
Then anyone who gets on a cruise ship with those terms, widely known, obviously, since 1991,
Not
does
responsible
so,
for your death.
does so with
I mean, it says it.
knowledge.
It says it.
So you would hold these people, whether you be a law school graduate or a 6th grade graduate, you're gonna hold them to the same standard?
Absolutely. But when I was director of life support at the Florida Aquarium, we had a large tank out front, and we watched a sand tiger shark one day swim by very lazily and take the back half of a parrotfish off. And of course, all the kiddies went berserk because we had those blood in the water, and that was a life lesson. I looked at that as something that people ought to learn. Big fish eat little fish. You're not going to change it.
And those 2nd graders should have learned that early.
I certainly didn't think we owed a public relations term to apologize for the laws of nature.
Yeah.
And when a duck flew into the baby alligator pen and became duck à l'orange, there was another lesson: the stupid shall be punished.
And that old woman got stuck in the elevator, what are you gonna do?
Well, that's here you've got you have immutable laws of nature, and you in this case you've got if you can afford a Carnival cruise, you're not a 6th grader illiterate. You're paying some significant bucks to go cruise to the coast of California or Mexico.
Unless
unless they're
6th grade education can come up with $500. You're not gonna do a
Cruises
carnival.
aren't that expensive.
I agree with what you're saying. I wouldn't necessarily agree with these are widely known, because if they were widely known, it would have been on the front page instead of the back, right?
Except, see, here's your problem. In this case, they do say they knew. They say they knew. And so that whole issue is off the table because they say they knew. And that's what I was going to quarrel with, Francis, is you're saying, well, that's the mistake the lawyers made. But if the clients come to you and say, well, we knew it was there, you know,
But did they
well,
know what
you
they
can't blink it away and tell them to lie.
Did they know what that meant? Did they know what that actually meant? What they were surrendering?
You read the clause. It's pretty, I'll read it again to you. It is agreed between the passenger and the carrier that all disputes and matters whatsoever arising under in connection with it or incident to this contract shall be litigated, if at all, and before a court located in the state of Florida, USA, to the exclusion of the courts of any other state or
This contract. So what is a contract? I mean,
But
we're college graduates and we're learning about contracts here in law school.
is that really not understandable to most people, what that would mean?
On its surface, I would say the contract is the purchasing of the ticket, the buying and selling of the ticket, not slipping on a piece of something on the boat, slipping on a
Whatsoever arising.
That's pretty broad.
So then where would it have gone if?
I think it's
before
overbroad. I
they
think
ever
it's-
went on the cruise? They get the ticket,
I
they
don't
read
think,
it.
I
then
agree,
they
I
go
don't
to
think
the lawyer
they've, I
and
don't
say-
think they've agreed to the terms of the contract,
Yeah,
they're not
what-
bound by that, they could file in Washington State to avoid the contract and get return of their good, return of their money.
Right.
I think that would be a logical,
Carnival
I think
sends
that-
them a packet, they open the packet, here's your informational brochure, here's what you're gonna expect on your cruise, and here's your tickets. You have the opportunity to read them, and then it says, upon acceptance of these items, you agree to the terms contained herein.
I would have argued that was what you just read is overbroad and ambiguous.
okay, but
Yeah,
let
we
me
can
ask
argue
you,
that and get you away
you're one of
from it.
those damn tort lawyers that he's looking at. Let me ask you this though, okay, because does the analysis change
Right.
if they hadn't read it? Because I'm thinking about all of those online transactions you enter into, where you could read it, but you choose not to be made aware of your rights. And you're gonna say, well, I didn't check, and is that gonna save you? Because I don't think it does save you. I think if you have the ability to have the knowledge, and you choose to be ignorant about it,
I think Carnival
Same
Cruise Lines
result.
owns an obligation to the passenger to make it understandable, and so.
well, does anyone other than Francis think that that's not understandable?
To us, but to the passenger, to a typical cruise line passenger. Put yourself
Well,
in their
but then
shoes.
shouldn't they bring it to someone? Right, I mean, that goes
No,
back
they
to some of
would-
the early
yeah,
things we
but
had,
they
well, you
would-
gotta notice that you don't understand it, you can't read the language,
Yeah,
so you
but then
just
what-
sit there and say, don't have to worry about it?
Yeah, well, then we're back to the paralyzing commerce idea. You know, what do? Do we stop in our shoes and every time we see a disclaimer or some kind of conditions to a purchase that we're going to make and say, whoa, time out. Let me call
There you
Judy
go.
Cohen.
Yeah, go for my lawyer.
Yeah, let me
Go ahead.
call my
Well,
lawyer.
it comes down to, you have the opportunity to review the material, understand it. If you look at it, you go, gosh, I have no idea what any of this means, I should really find out before I agree to it. 99.9% of the people will say, well, I don't know what this means, before I agree to it, I should probably figure that out. And the 1% or the 0.1% of people who are too stupid to care, well, they got what they've got coming to them, according to John. So, it comes down to, you have the opportunity to understand it, and if you don't, to learn about it. And you have the opportunity to raise it back to Carnival and say, I don't accept these terms, here's your ticket back, I want my money back. And they didn't do that in this case. And it almost goes down to when you sit down with a client and have them sign their affidavit saying, this is what I'm submitting to the court, I need you to sign off on it. Sit down, read it, go over it, I'm gonna go back to my office, I'll come back in 20 minutes. You're giving them the opportunity to. You're leaving the room to let them decide whether or not they read through it. Some clients won't, some
Yeah, but-
clients will, but they have the opportunity to.
But opportunity isn't the only element of a contract.
But
We
you
all
are
know that there's
choosing
more
to
it than
not
that.
exercise that option. You have the ticket in front of you, and you can say, I'm going to turn the ticket over and read it and learn about it, and you chose not to. Oh, I got my ticket, I'm going on my
You're
cruise.
accepting the terms one way or the other, by
Right.
not rejecting them.
By choosing not to read it, or when you're downloading iTunes, it says skip and accept all. And you don't have to read every page, you scroll to the bottom of the first page and skip all, accept, continue on your download. You have the opportunity to, but if you choose to do so, you are accepting all the risks that come with that.
But if you're a hoodwinked, okay? if
But you're
it's-
not
if-
being
if
hoodwinked,
the
you're
terms are
stupid enough to not read it.
If the terms are misrepresented to you, if the way
wasn't
it's presented
any.
to you is unconscionable, it's determined by a court, not us, okay?
Right.
But
That's not the issue here. The issue here is whether or not I can sue my home state because I slipped and fell. Well, you read the terms, or you didn't read the terms, but the terms are there and you agreed to it. Too bad. You gotta come over here to sue me.
Okay, we got more cases to do today. Guinness Hop versus Joseph Slits. And again, we are seeing business agreements have similar provisions in them because businesses often hate the length of court proceedings, the uncertainty of the decisions and the like. And so we see these agreements not just in the consumer situation, but in businesses as well. And the interesting issue that comes up in Schlitz is, okay, we have an arbitration provision, but what do we do in the interim with respect to, well, what if we want to force someone to actually honor the arbitration provision, or can we resort to the courts in order to get some type of interim relief while arbitration is pending, which is an interesting issue for you to think about, because that does become a problem sometimes, is just sort of the mechanics of scheduling the arbitration, getting in relatively quickly, and what happens with the status quo in the meanwhile. So I thought that this was an interesting case for you to look at, because the question becomes whether the agreement provides for maintenance of the status quo during the arbitration, and whether the availability of that relief is going to be then determined by the court or by the arbitrator. Now, one way to obviously attack that problem is for that to be in the agreement. So it's something for you to think about if your clients come in with a provision along these lines as well. Can we go to court to force arbitration? Can we go to court to maintain get an injunction to maintain the status quo? Or will the arbitrator be the person that decides whatever it is? Well, then we better have a provision for being able to select an arbitrator very quickly, or to default to an arbitrator in the event we can't agree on selection, because depending on who I represent, maybe I want to delay the arbitration, or maybe I want to accelerate it. But this all becomes a problem when we start to think about injunctive relief. Usually operates within days, and certainly no one wants to lose their beer distributorship, which I'm sure is incredibly valuable, especially in Canada. So, and so the question is, well, what can we do in the interim in essence, to preserve the status quo? And I think the language on really the second to last page of the decision is important. And it does, this is also the first introduction you've got to what's called the Federal Arbitration Act, which, when you look at the act in the cases interpreted under it, what you would find is that that act in the federal courts really favor enforcement of these arbitration provisions. And they if you didn't like Carnival Cruise, you're not going to like the statute or the decisions under these case law, because if you've agreed to it, you're likely going to be bound by it. And the question then obviously is, well, who agreed to it and under what circumstances should they? But as it says here, a federal court is entitled to adjudicate issues relating to the making and performance of the agreement to arbitrate. And so it may well be that you could get specific performance, or get the court to order specific performance from the federal court, including maintenance of the status quo. Now that's a contractual provision that you negotiate. What if the contract itself said that you could terminate prior to the arbitration, and the fact is that only the arbitrator could decide whether that termination was appropriate or not? You actually probably could negotiate away even the maintenance of the status quo during that period. So I think it's an interesting case that there will be circumstances where you will have to likely revert to attempting to maintain the status quo by resorting to get a court to order such performance. talk a little bit about Merrill, Lynch, Pierce, Fenner, and Smith, the Rosenberg case, which was decided by Judge Gertner. And as I said to you, I think Judge Gertner is a very different, courageous federal judge whose background is very different from most. She's actually also going to be the Law Day speaker and award recipient. I think at this point, she's been a federal judge probably for maybe as many as 15 years, I think. Her husband we previously honored, he's the director of the American Civil Liberties Union in Massachusetts as well, one of John's favorite organizations, I'm sure. But Judge Gertner, and I think the plaintiff is very lucky here, because what they're trying to do is invalidate the arbitration, the required arbitration provision. And that's another reason why companies like the arbitration provisions as well, is the secret nature of the proceedings. The fact is, if I want to find out what's going on in federal court in Boston in Brittany's case, we can go downstairs, log onto my computer, and we can pull up all the pleadings and everything else and see exactly what's been filed and where the status of the case is. In an arbitration proceeding, you don't have access to any of that, and so it's all quiet. And another reason why lots of businesses and even individuals at times will favor that type of resolution, because whatever happens is private. But what they're trying to do here is invalidate the arbitration provision, and attempting in the process to show that that because race and gender claims are different from other forms of discrimination, that they should be slightly different procedures in place as well. And in order for her to try and void the required arbitration provision here, she's going to have to try and show that the process itself is rigged against the individual who must arbitrate her claim. And the problem with that is, in order to do so, she needs discovery of the proceedings to get to it, which is, again, sort of gets her into this catch-22 situation. But she's lucky in this case because she's been able to convince a more progressive judge than most to give her access to some of that information, which might allow her to make a case for voiding the arbitration provision. I still think it's a very difficult case to make, but at least she has some ability, if she can get this information, to show that the process has been corrupted to the point where she is not likely to get a fair arbitration. So she's got a better shot than most. I think she's probably extremely fortunate that the lawyer she's got, the judge she's got, probably doesn't see things the same way 90% of other federal judges would see most cases either. Not to say that her decision is without merit, but most judges, federal judges especially, are very conservative. I think most judges, for the most part, are conservative, but not all. I mean, conservative in thinking in their approach. Let's talk a little bit about Thiessen versus GECC. This was filed as a class action under the Age Discrimination and Employment Act, another discrimination claim. We see a lot of these now in federal and state courts. Defendants obviously deny it, and the question becomes at some point with respect to the class action and the like, and talks about the standards for a class action that we talked about already. And the class at some point then becomes decertified. To what extent these claims have to be resolved through the arbitration process, and to what extent these individuals can still pursue these individual claims as well under the circumstances. And I think what I want to talk a little bit about in this regard, and in regard to Circuit City, which has since gone out of business, is the growing prevalence of private employers to insert these provisions within their employment agreements. And I tell you, I'm sure you guys have heard me say, my 18-year-old son came back from Circuit City one June when he was looking for a summer job. He's got an agreement this thick that they said, well, come back, bring that sign back tomorrow, and we'll pay you, we'll give you the summer job at $7 an hour, God knows what it was. And the employment agreement for this 18-year-old really was that thick. And most of what it was waiving various rights to certain actions, and most specifically, agreeing that under no circumstances would he go to court for virtually any claim, that he would agree to an arbitration provision where whatever claims he might have would be resolved there. You know, having a mother and father who were both lawyers, the majority of his life has been a serious problem for him. And it was in this instance as well. Because you looked at it, and this is what struck me, and this is what I wanted to just ask you about and think about, is, and he was a smart kid at the time as well, probably even as a high school student, more educated and knowledgeable about these things than most. Isn't there something incredibly unfair about an employer asking a employee of limited means, limited resources, and on many accounts, as a condition of putting food on his table, to have to waive even just simply the right to go to court?
John said, big fish eat little fish.
So that's it.
Survival of the fittest.
I mean, that's where we've come to.
Yeah, you don't sign it,
We
you don't
come
work.
there, one bloody lesson at a time. Guarantee you that every clause in there is a lesson written in blood by some tort lawyer, taking this 35%.
Some tort lawyer, you know, you act like those corporate lawyers you know, some of the lessons might have been originally begun by the corporate lawyer, not the tort lawyer. You know, the fact is that you can keep attacking these tort lawyers, but it's the tort lawyers that made cigarette smoking a little less fashionable and a lot more financially risky for those companies. So, you know, and the reason probably why you have seatbelts in your cars these days as well is at least in part attributed to tort lawyers, and the fact that we don't have so many alcoholic doctors as surgeons may also be attributed to that. And I'll say thank you for each of those things. But is that what it is? So, tough luck. You want to work a summer job, you want to go work for Raytheon down the street or Walmart, where they're going to take advantage of their employees on a regular basis till they get caught, or some other big box store. Because I've got my own story, but I'm not going to go into that now. You don't have some obligation to stop some of those abusive practices? Because wouldn't you love to have gotten in on the Walmart one? Go ahead.
I mean, I think personally it should be against public policy, so there's got to be some future legislation, otherwise you'll never change the system. You know, or you have
So
to
it's a
have somebody-
legislated solution at this point, not like.
Well, that, or you need basically, you know, a real tough-ass attorney to just, you know, push the envelope. You know what I mean? But it's really hard to get that to happen because these, you know, these causes aren't worth a lot of money, so you got to have someone that wants to do it pro bono and wants to fight to change the system, because unless someone steps up to the plate, that's not going to happen. I mean, that's the problem. Because it's a financial thing.
I think that in this.
Can I ask how many of you, I'm going to let you finish, how many of you might have signed such an agreement with your employer or?
For arbitration? To the age of 18?
Yeah.
Before the age of 18.
No, at some point in time in your career.
Maybe.
Oh, had signed?
Yes, yeah.
Probably, unknowingly, yeah, we probably.
So there's about a half a dozen of you have your hands up though.
Yeah.
Go ahead.
I would just think that in this case, it's different than the Carnival Cruise Line, because now we're talking about an employment contract, and now it's a little bit adhesive, because there is the public policy, and people have to work. People do not have to go on a cruise. A cruise is a vacation, it's a luxury.
But do you have to work here?
You don't have to work here, but there are very few low-level starting entry jobs for people, and you have to start somewhere. And I think that this is adhesive, and I think that this is not right to make somebody starting out in their first job, 18 or whatever the minimum age is to work, waive all of their jury rights for a trial because, because they need to take a $7 an hour, minimum wage job. And your son was lucky, he has, parents to say, whoa. But maybe he probably didn't even necessarily have to work at that place, but there are people out there now that have to work. They will do anything because they have to work. And then, so they get this $7 an hour job and they say, oh, thank God I have this job. And then they sign this thing and then they slip and fall and then they're in trouble. So I do agree. I think that there should be some kind of public policy out there that you can't have arbitration clauses in employment contracts for certain levels.
Serve them a 90-degree.
Well, I mean, like if it's like an employment contract, and it's a high-level management, there's a little bit more sophistication, level bargaining power, maybe because you're not going to get it all. The legislator isn't going to give it all. You got to start slow.
What about the argument that this fixes the business costs, allows them to reduce exposure, and therefore potentially hire additional employees without that type of risk?
Well,
because some employees aren't going to work out.
Well,
And I don't want to have to be litigating stupid claims in court for ages because I've got a worker who doesn't work, doesn't want to work, but simply wants to get free money.
Are we talking about employers in the civilized world or in sweatshops?
I think
What do
you mean by that?
We're one step away. That's what we are. When we lay out all these rules and disclaimers to prospective employees, we're limiting their rights, their access to the judicial system, which will allow us to just do what? Run rampant and compromise their rights and compromise their safety in the workplace, so that they're forced down this long road, this funnel into a narrow set of relief.
I don't know. I'm not sure it's that slippery of a slope, Francis. I mean, I understand the analogy, but we haven't removed their right to pursue relief. We have limited where they can pursue relief. But I'll tell you, especially like in some contexts, say the discrimination context and the like, if you're removing my ability to sue for punitive damages as a result of that's a significant loss to the employee. There's a damage award from Worcester last year for a pharmacist who was discriminated against. It was $1 million punitive damage award because tried to get them to stop doing what they were doing. They still didn't do it. The punitive damage award alone was over $1 million. So if you are removing my rights to seek some of those damages, or to seek the right to have a jury determine some of those damages, and we are by these agreements, well, that's a significant limitation potentially on an employee's right.
So they don't get to play the lottery, which is what you're saying here.
Well, no,
as far as
I'm
the
saying
slip
when
and fall,
Walmart for decades discriminates against women, is made aware of that, doesn't do something about it, that I don't see it as unfair to allow the employee who finally is able to get to court to seek redress and to make sure that Walmart, it's not financially feasible for Walmart to continue to do that. And I think the way in which you discourage that is from a business standpoint, is when they are hurt sufficiently, that'll curtail the practice. I don't think there's any doubt about it. I mean, my own experience indicates that with some of the cases I've had more recently, is that it's got to, and it's obviously self-serving to say it, but it's got to be financially disadvantageous for them to do that type of activity again, or they'll do it again and see if the next guy can take them all the way to the map. And if he can't, then they've made money on the process. I mean, that's what makes businesses change their practices, in my opinion, is it's got to be enough to make it hurt. Go ahead.
I was just going to say, regarding arbitration and the effect on employees, if the employee is a member of a union, the employee is not even the party, it's the union that's the party. So whether or not the union...
Oh, it's a collective bargaining agreement?
Yes, collective bargaining.
That's all in state flux right now, too, isn't it?
So that's one issue. And the other issue is regarding suing an employer is, for example, some kind of injury or retort. I believe the Workers' on the.
Fair enough, right? There are certain claims that you're not gonna be able to pursue anyway. And I was gonna ask you that, from the government standpoint, you guys, as a government employer, as a member of the service, did you have to sign any additional forms, or your
No.
rights were even more limited, you were limited to what was available? I mean, you were claims against the United States or whatever, or,
I didn't sign an employment contract. I took an oath of office.
but, okay,
That was it.
and that was it?
That was it. I took an oath of office.
Okay, but your rights to, as to what you would be allowed to do if you were in the event you were injured, or the payments that were due,
That was all statutory.
well, statutory, right? Okay. So there's no additional, okay?
Some of your larger firms, though, I had an 82-page employment contract that I had to sign because this large company bought my software company.
Big fishy, little
And
fish.
it just, yeah, totally, but it was just, I mean, you're sitting here and you're giving this off to people that, you know, are at this level of the company. I mean, I was up here and there's people down here, they're all coming, going, what the hell is this? And they can't have their job, and they held their paychecks until it's signed. You either sign.
Well, and
it or
see,
you-
that's what seems, and you want to talk about adhesion, as you said, this isn't a trick
That
now.
doesn't
I
sound-
need to pay my mortgage and put food on the table tonight, and until I sign this ridiculous agreement that I can't possibly comprehend that quickly, I'm not getting this week's
There's
paycheck.
gotta be a law against that somewhere.
You know what, you would think so. I see it all the time.
So for the midterm, we should, like, if we put in big fish eat little fish, and there's a
Little picture.
Remember the parable of the carrot?
I was thinking like a little fish, a medium fish, a bigger fish.
Look at Bill, see if they still have that contract. It's-
I'd like to see it.
My father said he'd never in his life seen anything like that. He was like, oh my God.
Oh, the life lessons I learned.